Um,
Let's
Matt, do you have the ability to screen share if necessary?
Yep.
Thank you.
We're gonna do that. I'll do that when you're ready to
So
jump.
I'll
Or I guess I could.
introduce us. My name is Mario Capola. I am the Corporation Counsel for the city. I know some of you, but not most of you, so it's a pleasure to meet you. I'm here this evening with my colleague from the Law Department, Assistant Corporation Counsel, Matt Sapienza. Matt has been for a number of years in charge of our land use work in the city, has done a great job with it. And also with us is Nick Beaumonte, who is a partner in my law firm, Birchall Moses. Nick, as well as I, work within our municipal practice group. We represent a number of municipalities throughout Fairfield County. Probably about 25% of the county as town attorney. And Nick is also the appointed town attorney in Woodbridge, but also works with Westport and Wilton and Weston and New Canaan and Easton, among other municipalities. So we started to do this year, or started late last year to schedule the sessions and started to have them earlier this year with some of the city's land use boards and commissions. Under state statute, there's a new requirement that the Planning and Zoning Commission members conduct a certain amount of training during their term, during each and every term that they have. I believe that's the only municipal board, commission, or agency that's required to do training for each member for a certain period of time, for a certain number of hours. However, as a matter of best practice, I think it's a good idea for all boards and commissions in the city to do training, and we've done limited training in the last probably 10 years, and we've certainly we're hoping to do more of it. So we're happy to be here this evening for this training session. As we've done it in the past with other boards and commissions, this is informal. We have materials that we put together for you. I believe, Mr. Chairman, have those been distributed to everyone?
Mario, I don't think we sent them yet because they were, kind of finalized recently. And in the past, the way we've done it with the past few boards is we almost sent it afterward because again, we don't want people member. We're going to share them. We're going to go through them together, and then we're happy to send them to the commissioners for their perusal afterward. But some people were feeling like they had to study for a test, and that wasn't our intention.
That's fine. Yeah, we typically set and provided them for some boards and commissions right before the meeting. But I think it makes more sense to do it afterwards, so we could go through it first with you. So Matt will be putting the information on the screen as we go forward, and we're providing everybody with a hard copy. We're providing your staff with a copy. They'll email it to all of you so that you'll have a copy of the presentation in detail. And as we go along, if you have questions, please feel free to ask them. You don't have to wait till the end. Again, this is informal. It's for your benefit. So this is your training session. So as we go along, please ask questions. If there's anything you want us to hit on as well as we're going through it, let us know. Obviously, we're not going to be able to render legal opinions this evening on complicated questions, but we'll do our best to answer questions regarding the material that we're going through. So with that being said, who's I'm trying to look here. I think it's
I'll take it. I'll take us first, Mario.
Thank you.
All right. Good evening again, everyone. I think what we're going to do here, just to set the stage a bit, I'm going to quickly, this outline that you'll get soon, you'll see comes out to 8 pages or so. There's plenty of minutia to drill down on. We're not going to do that tonight. We're going to take a higher level so that we can get through the material and try to address questions that are most pertinent to you folks. So what we're going to do, I'm going to run through, again at that high level, just what the legal powers of this commission are, and where those powers come from. Matt's going to touch on the process for actually affecting some of those powers. And then we're going to get into some best practice considerations for everyone as commissioners in terms of your conduct and in terms of some other laws you should be aware of, namely the Freedom of Information Act and what that means in terms of meetings and in terms of your records. So let's just get into it. Your power, all power of municipal boards and commissions comes first from state law and local charter and code of ordinances. So you'll see in this outline, we reference a lot of the enabling state law, which does give plenty of context to these powers that I'll describe. But I think for your purposes, the easiest way to understand what this commission does is to look at what your code says, because the code gets as specific as possible about these roles and the expectations of the city for this commission. So those sections in our code is chapter 69, which just talks about the harbor itself and some of the regulations that go along with that, as well as this commission's membership, terms, things like that. And then chapter 66A deals with mooring and anchorage. So those are really the two sections of your local Norwalk code that implicate the powers of this commission. So what are those powers? The main one, I'll just say all of these powers really are advisory. When push comes to shove, the legislative body is the entity that's empowered to actually make changes to things like code provisions regulating use of the harbor, to ultimately adopt a harbor management plan, which is one of the main powers and roles of this board, and I understand of this commission. I understand the last plan was initially drafted and approved back in the early 90s, and I think the last time it was amended was in 2009. That was subsequently adopted by your Common Council. But this plan is really a working, living document that lays out what you and this commission, in your expertise and in your research, sees as the best use of the harbor. And there's a lot of aspects that go into that. There's a lot of pieces of that plan. It's a very robust document. And if the commission were to contemplate changes, there's a process for doing so. And Matt will touch on those a bit later. Again, there's also more general advisory power to the Common Council. So this commission's authorized to do things like studies about the harbor, if it's going to present pertinent information, if you wanted to change a regulation or a local ordinance that applies to regulate the harbor. You also have some advisory input in terms of the fee schedule for the harbor, again, which ultimately gets approved by the Common Council, but that is a role, an advisory role this commission serves. And then again, to the tune of recommending regulatory changes with regard to the harbor, you can advise the Common Council on what changes you might want to make to restricted speed zones. Another large advisory role of the commission is review of applications from other town boards and commissions that are abutting to or part of the harbor. So under our code, it specifically says, so all proposals for dredging, filling, and constructing or altering any structure on, in, or contiguous to the harbor to ensure consistency with the harbor management plan. So what that means is this commission should see when another, for example, the P&Z Commission, receives an application for some sort of development on or around the harbor, then that could be or should be under the code a referral to this commission to potentially provide input if it's warranted on that application. You don't get to decide the application, but you get to give, again, advisory input. That's similar with other entities that use the harbor. This commission also serves an interface role, an educational role. So for entities, organizations that provide services or facilities to or from the harbor, this commission acts as sort of an oversight or go-between for those purposes. The commission also has authority to enter into certain contracts, employ consultants and other assistants, and basically expend funds to do your duty. But as specifically authorized by the Common Council and in compliance with the city's procurement guidelines. The commission also has the ability to adopt its own rules and regulations and plans as it deems necessary. Attorney Sapienza and I discussed this earlier, and sometimes that could create more problems than it solves, especially where there's already an existing fairly robust set of code provisions that regulate the harbor, but that is an option for this commission. And then as we go on, there's certain permits in very limited cases that this commission does actually have the authority under, again, the local code of ordinances to approve or deny. So the examples out of the code itself: motorboat regattas, races, speedboat trials, water skiing, those types of events that require a permit, that's under the purview of this commission. And then again, I mentioned chapter 66A for mooring and anchoring. There's certain provisions within that chapter that pull in this commission for some oversight. Again, largely advisory, but this commission does serve a role under our code in terms of mooring and anchoring occurring at the harbor. There's a couple other powers that I think Matt drilled down on a little bit more, so I'm going to kick it over to him, and then I will be speaking again when we get to the freedom of information section. So Matt.
Thanks, Nick. I think where we left off, another power is the ability to nominate a harbor master. For the governor appoints the harbor master, but the commission can nominate not less than 3 individuals. And another power, I guess, just in general, obviously the Harbor Management Commission has power over the harbor and defining the harbor. And it's interesting the interplay with multiple agencies that all have jurisdiction over the water of some sort, whether it's a harbor or the coastline or many of the other kind of very technical names for different aspects of our waters. Generally, there's some cases that eventually, occasionally, jurisdictions collide, and there are some cases, the nuances we don't need to get into too much now, and the cases aren't too frequent. But generally, the case law seems to indicate that in the statutes that the state of Connecticut through DEEP generally regulates waterward of the mean high water mark. But DEEP has also delegated some of that authority to municipal harbor management commissions. So it's kind of a concurrent jurisdiction between DEEP and the Harbor Management Commission for anything waterward of the mean high water mark, which again is kind of a technical definition that I'm sure you probably even understand better than me, but it has been explored in a few cases, which was pretty enlightening for me. Landward of the mean high water line, the Planning and Zoning Commission has primary authority, and they do that largely through coastal site plans. The Planning and Zoning Commission isn't bound by the harbor management plan or the commission, but if as Nick mentioned before, certain items that go before them have to be referred to the commission, and if the commission doesn't approve them, then the Planning and Zoning Commission would need a more than just a simple majority to still approve the application. So when Nick says that some of your powers are advisory, that's true, but some of them are slightly more advisory and maybe not quite binding, but they're not merely advisory where other commissions can always disregard them. They actually do have to overcome a simple majority in order to if the Harbor Management Commission doesn't approve. But the jurisdiction water word of the mean high water mark that's shared between the state and between DEEP and the Harbor Management Commission. Some of the cases that have explored that, which again are not common, but they're out there, and they indicate that the harbor management plan itself has to be approved by DEEP. So when the commission enacts a harbor management plan or amends their harbor management plan, that first has to get approved by DEEP before it can be amended. And so then the courts have said, well, if DEEP amends the plan, then to include something for the Harbor Management Commission, then that is an indication that the Harbor Management Commission has jurisdiction over that issue instead of DEEP. In other words, DEEP, they interpret DEEP as delegating you the authority because DEEP approved the plan. So, but if it's not in the plan, then DEEP probably has a default jurisdiction. So again, I don't want to get too much into the cases, but it was an interesting analysis of the interplay between the many agencies, governmental agencies and boards that deal at least a little bit with water related issues and applications.
Matt, is that Cohen versus Greenwich you're talking about?
Yes, that was one of the most recent ones that really explored it. There's DiPietro, there's a few others, but yeah, Cohen versus Greenwich was one of the most.
We're well aware of that and the repercussions.
Yeah, but so interesting case and an interesting analysis, I thought. But great, that's awesome. You guys are aware of that as well. Okay.
Yeah, but Matt, can I just interject? They said also
Sure.
to that plan is that if the particular application is not clearly specified in our plan, that we do not have the right to review it. Now, that certainly makes no sense to me, because how can you a priori know what projects or what application is going to be submitted that's already incorporated in the plan? Case in point was the Walk Bridge project, where this Kathleen Reiser, who was the reviewer officer in this case, negated all of the recommendations the Harbor Management Commission made on the basis that we do not have the right to review an application from the state. And because the Walk Bridge project was not clearly specified in the Harbor Management Plan itself. And I found that to be quite troublesome, because how can you a priori know what application is going to be put and you could put in the plan? But I'd look at the plan as a guideline at which we can make comment and respond to an application, not that the application has to be specifically cited in the plan. And that's what that court edict had mentioned to us.
And that's a reasonable position, John, and I think that's great. And actually, I've seen that's come up. I've seen a little bit. It hasn't really been decided upon, but it has been touched on by the court. Or at least the court. I remember in one case, it seemed to make it aware that was a position some Harbor Management Commissions held. I can't at this point talk about a specific issue. That this presentation is going to be high level, but if that comes up in the future, where someone's challenging and you want to explore how that relates to a specific issue that we're pending and there's an actual issue, please reach out to us, because it kind of takes a little more particular analysis. But generally, that is a point that that's not the first time I've heard that point, and it's a good one. So the law department's happy to help you explore it as it applies to a specific situation going forward.
Other commissions in the state have been troubled by that one aspect of the plan, and that didn't clearly specify in their plan. And the DEP, or the applicant had made mention themselves, and the lawyers for those applicants had made mention that, again, that plan is not, that recommendation is not justified. So
that's very interesting. So yeah, next, and bring it to us, and see what your lawyers say. Will be your best recommendation, but it's helpful to be aware of what other lawyers say as well. But
right.
And then ultimately the judge will be the final arbiter. But in the meantime, yeah, for specific stuff, it's a great question, and we'll be learning. Next presentation, maybe we'll have an answer for it. So
okay. Thank you.
Yep.
And I think
Uh,
unlike other boards, in contrast to other boards and commissions, I mean, we focus here on powers of the Harbor Commission because the powers are not as clear as for other boards and commissions. It's more nuanced. And I think one example is when land use applicants are dealing with the Harbor Commission, a lot of times they're not exactly sure what the role of the commission is. And I know that over the years, your commission has educated people as well, and your staff has, as to what the role is of the Harbor Commission. So moving on to procedures.
procedures. So I won't spend too much long on procedures. We've kind of from the outline, we've pretty much taken these almost verbatim from an ordinance or statute. So, but it's just, you know, as a law department, we always want to emphasize to follow the procedures. So this is an outline, but if you're going to have an application, I'd almost suggest don't just follow our outline that we'll send to you, but actually look at the statute, look at the ordinance because sometimes they change even after this outline will be sent to you. So procedure is just important always, and you want to do your best to follow them. And the best way to do that is to read the statute and ordinance. And if you have trouble interpreting it or understanding it or following it, that's what we're here for. Please reach out to the law department. And we can kind of go, talk through any ambiguities for it. But, their deadlines, dates, so I won't read them all. But interestingly, the only ones I'll highlight are that certain matters do require a public hearing. So, if there's a public hearing, then we'll talk about appropriate procedures for public hearing. We're going to get to that in a little bit in this presentation. But there's a difference between applications that can be decided just at a meeting with just deliberation of the commissioners yourselves. And then certain applications do require input from the public, in which case you listen to the input from the public and then you make your deliberations and decisions. So just beware of following the timelines, deadlines, procedures, and that are contained in all the procedural rules.
Thanks,
I think
Matt.
that brings us to the Freedom of Information Act, which I think Nick.
Thanks, Matt. All right. Obviously, we've gone over some of that higher level powers and authorities piece. So we'll move into some legal considerations that we want to make sure you as commissioners have at the forefront of your mind in serving your roles here. So as many of you, I'm sure, know already, having been commissioners, this commission is an agency under the Freedom of Information Act. Freedom of Information Act is a section, it's a bunch of sections of state law that effectively does two things for public agencies, which again, you are one of. It requires that your meetings be open to the public, and it requires that records within your possession that relate to your commission duties are also available to the public. So what does that mean practically? In terms of meetings, a meeting is not just when at least 5 of you actually get together somewhere and have some sort of a meeting. And that is the threshold. I say 5 because under the Act, a meeting that requires public access and public notice is a quorum of the full commission. So this being a 9-member commission, that number is 5. But what I'm driving at here is a meeting is not just a get-together. If you look at the definition here, you also see any communication by or to a quorum of the agency. So that means emails, folks. We need to be careful. We can email each other about, and typically this would come from Amelia or staff, about, hey, is everyone available on XYZ date for a special meeting? Here's the agenda. Here's a copy of the notice. That's okay. But as soon as someone clicks reply all, and makes a comment, that can be seen under this law as a meeting, an illegal one, because the public would not have had access to that meeting. Even though it's emails kicking around amongst a quorum, under this law, the public should have access to that. So this is a cautionary tale. Be careful about sending emails to the group. Do not get into any sort of substantive discussion about anything that's on your agenda, or that was on your agenda, or that you expect to be on your agenda. These meetings, your meetings like we're having tonight, the discussions have to be in public. And staff does a really good job of following the rules under the Freedom of Information Act for getting sufficient notice out and published so that the public's able to attend these meetings. Even if they're not able on your agenda to comment, if there's not a public hearing or a public comment period, they still at least have the right to access. So just looking at my outline here. Okay, so if you were to email the group about an item that's coming up on an agenda, not only does that potentially violate the Freedom of Information Act, but it could also provide the grounds for someone who might not be too happy with a decision or recommendation that you've made or not. It gives some grounds to challenge, because someone can claim, oh, well, see, this person was biased. And that's reflected in these emails ahead of time. Or this person predetermined what the decision was going to be. Those are two terms of arts that we see in our legal field that gives rise to an appeal of an action of a board or commission in court. So Mario's going to touch on that a little bit more, but I just add that for some color that, you know, emails, trading emails around, we see it all the time. It's a major, obviously, one of the top ways that we communicate today. So that's why I'm focusing on it.
Nick, can I ask you a quick question?
Sure.
So I'm the secretary. So when I send the minutes out to the commissioners and say, let me or Amelia know if you have comments, am I not supposed to do that?
The way that I see it mostly done is the draft minutes get distributed ahead of the next meeting, and then the discussion really takes place at that meeting when the commission is considering whether they're going to ratify the minutes, you know, from a draft form or not. So, I mean, if there's comments that are coming to staff directly and not, and again, whether that rises to the level of substantively discussing a pending application, I mean, I don't want people talking about the merits. If someone is saying, hey, you know, I remember so-and-so actually saying it a little bit differently, you know, I think that's more clerical. But really where the opinions start coming out and saying, well, yeah, can you believe so-and-so said that? That's what we're saying should not be getting across. Does that answer the question? I mean, I guess the way I typically see it, and Matt and Mario jump in, you have draft minutes. The minutes get added as draft to the next commission meeting agenda. And then once you get to that item, if anyone has any changes, they raise them then. And that's how you finalize the minutes.
Yeah, that,
And so, okay,
I was gonna say
go
that's-
ahead, Maria.
I think that's the best way to do it, and to have discussions regarding any issues that anyone has with the minutes. You know, there was a mistake, there was a misstatement in the minutes, to do that on the record in a meeting. And, you know, I think if people are prepared, so when the meeting starts and the minutes come up in discussion, it usually only takes a couple minutes to resolve those issues. And I think it's always best to do it on the record.
And
Okay,
I agree it's the best practice. And if you want to talk in detail about, variations from that practice and explore them, you feel free to reach out to us, through Amelia or directly Lori, and we could talk through those one-on-one. But I agree that's the best practice.
Okay, thank you.
Thank you, Lori. Good question, though.
So I get,
All right, I'm gonna keep moving us through FOIA. There's not too much here. All right, so I said a quorum of 5 or more of you actually getting together is a meeting. Emails kicking around, substantive emails with amongst 5 or more of you is a meeting. I don't know how many of these this commission actually does, but a site visit also is a meeting. And there's great pains that are taken to still notice it according to the requirements under FOIA. But if this commission does do site visits, we just caution to try to avoid discussion at the site and save the discussion for when everyone's at an actual meeting on the record. Usually if there's a site visit, then you'll be accompanied by town staff, and that makes things a little bit easier. But just in practice, that is how it plays out, and it just flows much easier, and you don't run into issues if the discussion during a site visit is limited and it's really just for observational purposes.
And I thought we suggested, for a site visit, you have staff there, they may give you some directional guidance. You may want, telling you what you may want to look at and pointing things out to you. But I think it should really be limited. The discussion during a site visit, you should try to limit it to that. It's absolutely try to avoid any discussion, both with other commission members or with anybody else, whether it be an applicant or applicant's representative or member of the public that tries to engage you in discussion about the application. And it's easier said than done, but you really got to try to make sure you don't engage in that discussion regarding a pending application, whether it be a site visit or otherwise, while it's pending.
Thanks, Mario. Again, on meetings, obviously since COVID, remote and hybrid meetings are very much a thing, and that has been baked into the law at this point. So there is clear authority to hold your meetings remotely. The one caution I'll just say, and this is more for Amelia, if the commission is ever intending to have a remote only, so fully remote, regular meeting, there's some tighter timelines in terms of notice. So just be aware of that. And then I mentioned at the top of this section, your meetings have to be public. However, there are several limited circumstances where you can have an executive session. So that's a confidential, non-public session of just the commission discussing a permitted topic. Like I said, those are few and far in between, and we don't really see our land use boards and commissions using executive sessions very often. For example, the P&Z Commission, if there's a lawsuit, if there's an appeal, then that would provide a ground for executive session. If there's a pending litigation, then the commission could invite us attorneys in, and the public would lawfully be able to be excluded from that conversation. There is no baseline rule that, oh, we could just go into executive session to get legal advice. That is not a thing. So if there is a topic that the commission feels is warranted in private, we strongly urge you to consult with Corporation Counsel's office, and we'll help guide you through that. All right, last on FOIA is the records piece. So, like I mentioned, the Act allows members of the public to request and review public records, which includes any email communications, any text messages, any voicemails that you have that are related to the city business. So that includes not just if you have I don't know if you folks have city issued emails or phones or what. But okay, so
Yeah, and by the way, I'll just speak to that real quick. So, in the past, we've talked about, you know, for what boards and commission members should we have city emails. There is a cost to the city for every city email. I think it's an annual cost. You know, in a perfect world, as a lawyer, you say, hey, every board and commission member should have a separate city email address. Practically, we have to take into consideration the cost. And so I think the Common Council and the Planning and Zoning Commission do have, the Common Council members have I believe have city issued email addresses. And I think, and I know we were working on trying to get those also for the Planning and Zoning Commission, and maybe the ZBA and Conservation Commission, the thought being those boards and commissions that would be the most subject to litigation. But yeah, I mean, we understand that volunteer members of other city boards and agencies are using their personal email addresses for conducting their city business. And I always caution folks, you know, when you're a board or commission member, whatever email address you're using, you should assume that at some point in the future, if there's ever litigation or a FOIA request, it's possible that somebody's going to need to go, you know, run a check of your email, of your emails based on a certain word search. And so I always caution folks to that. But yeah, that's how we do it in Norwalk right now is, again, there's some limited boards and commissions that do have city issued email addresses, and otherwise we know people are using their own email addresses for their work with the city. And by the way, I also, one other practice tip, really try to keep your any communications you have via email for this board, and I assume most of you are doing this anyways, but limited to one email address. Try not to use different email addresses because there could be a point in time where you're asked to comply with a FOIA request or a discovery request in litigation. And the discovery request in litigation is, I've only seen it happen once. I've been with the city in corp counsel for 12 years. I've only seen it happen once. I've been doing land use litigation work for 20 years. I've only seen it one time happen in federal court litigation we had many, many years ago in a case. So that doesn't happen often. But the scenario where you're asked to search your email for a FOIA request, that does happen from time to time. Not often with the board or commission, but it happens from time to time. And you know, you should all be careful for that.
agreed. Thanks, Mario. So just to wrap on that point, the public it's not just emails. It's any other documents, whether it's hard copy physical documents or electronic files that you have saved on your computer, again, related to city business. It's all fair game if a member of the public makes a FOIA request for those certain records. There are several exemptions to disclosure of certain records, but that analysis is not for you folks to do in the event that we're managing a FOIA request. The attorneys make the assessment of what records are exempt from disclosure and what's not. For example, communications to or from your lawyers, not just any communications, but communications that are actually seeking or giving some sort of legal advice, those are exempt from disclosure. There's some other categories, but it gets fairly nuanced. So as a baseline, we would just say, assume that anything you put in an email or submit to staff is going to go into a public file, and that will be fair game for someone to ask for and look at.
Question
I think
about,
that's it.
I
Oh,
got
sorry,
one.
Alan. Yeah.
I just have one, with regard to executive session and things like personnel reviews and things like that need to be conducted in the public.
You have touched upon one of the 5 categories of executive session, and I always hear it represented as personnel matters. It's a little bit more than that, but where there is actual so let's say this commission has authority to hire or fire, for example, someone that you've hired through your procurement authority to provide some sort of service, some sort of opinion. If you're talking about personnel in that respect, then yes, I think that could very well provide a ground for an executive session.
For
But again,
example,
like,
we have a harbor master whom we make recommendation to the governor ultimately to hire. But when a reappointment is due, we send a letter with the commission's feelings about the performance of the incumbent, and if we would like him to continue and he or she wants to continue. I'm a little uncomfortable having that as an open discussion on television all over the city, simply because none of our commissioners would feel comfortable speaking up in front of the incumbent and the public about those things. You know, personnel issues, you want to correct a failing rather than to slap somebody over the head for it.
I agree, Alan, and that's, I think the legislature agreed too. That's why they put that in place. So just from what I'm hearing, and like Matt said, where there's a specific example, and I know you just gave me one with the harbor master, I think that would give rise to an executive session. That has to be properly, again, everything has to be noticed correctly. So you can't just say on your agenda, executive session. We've got to give a little bit more detail for that as to why, without necessarily disclosing what the substance of the discussion may be.
And just so you know, I mean, for example, with that one, if you want us to look into it, I would just ask you separately make that request, Alan, to us as chair. Because on that one, I think we may want to check with the FOIA commission. We do have the ability to reach out to the FOIA commission. They have staff members that provide us with input, and we quite often reach out to bounce things off them and get their opinions.
I was just up there this afternoon. So.
Yeah, so I think that's one I just want to double check. You probably could discuss it in executive session. However, I'd want to verify that with someone up at FOIA, because I don't know if the commission doesn't have a contract with the person, if they're not an employee, then I question, does it fall under the exception for personnel? Whereas, for example, Nick gave the example of like a consultant that you would hire. Discussions regarding not only that as a personnel matter, but also as a matter of contract, you have the ability to go into executive session to discuss contract negotiations and that type of thing. So I think that's a more clear example of, yes, you could go into executive discussion to discuss hiring a consultant. You could go into the executive discussion session to discuss the hiring of a staff person, where you'd have the ability, where I don't think you have the ability to hire staff, but anyways, they're assigned to you by the department. But there are times where boards and commissions do have the ability to, or input in hiring staff, and that would be subject to an executive session. Here with the harbor master, because you don't have a contract with them and they don't necessarily report to, they're appointed by the governor. I would just want to double check it.
And then the biggest one will be the discussion of pending lawsuits. But you guys have been great that we haven't really needed that much. And we know in the law department that you're going to continue to avoid litigation as much as possible. So we won't need that one ever.
Well, just to clarify, we pay the harbor master.
In the harbor again, so we could talk about that. That's probably more specific because again, I think the governor may appoint them. So there's
Correct.
issues, and so again, we might. That's just a perfect one to maybe we need
research.
research.
More than likely, you could go into executive discussion to discuss it, as Alan has suggested. That's just one I would want to double check, because it's not as clear cut as other examples. But
Okay.
yeah, we just want to double check it.
It's fine.
And that's we try to
understand.
from time to time, without guessing on things.
You understand that this is a person who's in front of a lot of people on the harbor in general, and has the possibility of being reappointed. And so you don't really want to have that kind of discussion in public amongst people who would be his whom he would be supervising or criticizing or whom he'd be giving direction. And we're kind of the boots on the ground for him with the commission to make the recommendation. You know, I just, even though we don't hire the individual, I don't know where else a recommendation would come from that would be particularly meaningful.
No, it makes sense. Again, I think you probably could go into executive discussion to discuss the recommendation, but again, just something we'd want to double check with FOIA.
I'll send you a note. Thank you.
Alan, excuse me, the governor's office usually sends us notification. I forget the fellow's name, Tom, he's in the governor's office. He usually gets in touch with me with regard to our authority of having to hire a harbor master. So they as far as I know, that we have the authority to review that and do that from their office.
So, yeah.
I don't know that. I don't know that
Again,
we
the
do.
statute will tell us, and that's what we can really kind of analyze for you offline. And
The only
as Mario said,
stipulation,
avoid guessing.
only stipulation that Tom had mentioned to me that we need to have 3 names of individuals that the commission believes that would be suitable for, you know, the harbor. They just want 3 names, and they allow us to triage those names as well as far as our first, second, and third choices. But the governor's has the right to choose the person that they would like.
That's my understanding of the statute as well.
Yes.
And again, also anything you submit to the governor, you know, they might have their own FOIA issues to consider. So there's a lot to kind of unpack, and that's what we're here for, and that's our fun. And I put fun in quotes there, but it's an important part, and you really got to just track the statute. And as Mario said, sometimes we reach out to the FOIA Commission itself, and there's a lot of smaller decisions that they publish that give us guidance. So some of these questions seem like they're open and shut, but once you start peeling back layers, there's a little more analysis there, and that's what that's what we do.
Thank you.
Nick, I think you wrapped
Yeah,
up
I'm all set on FOIA, I think, Matt. So that's it for me.
Okay, and I think we're almost we're definitely over halfway, which is good. So getting to the end, the next section I think is some best practices for meetings. You know, most of these I think are similar in other boards. There's a lot more administrative hearings and meetings where someone submits an application. I believe the Harbor Commission does some of that, but a lot of your public hearings especially are kind of legislative. So you have to have a public hearing when you amend the plan. And so that's probably your biggest area. It's a little more legislative for your public hearing. So sometimes it's some of the rules don't apply quite as much to you, but there's still fundamental rules of all public hearings. Well, in first, participation. Obviously, it helps to have good participation of the commissioners, and you should attend, you know, all the meetings to make your quorum. In certain circumstances, if you miss a meeting for an application, there are circumstances where you could still participate in the vote of that application by catching yourself up and representing that you've done so. You know, and if you don't, and someone can kind of prove that at court, that you're kind of unprepared or unknowledgeable about the application, you know, that could be detrimental to the decision. But nowadays, especially with Zoom and recording of meetings, it's made it a little bit easier for commissioners to catch up. But you really want to be present in person or virtually for every as many meetings as possible. Public hearings. When you do have public hearings, again, most of the time these come in the context of a application to do something, and then there's someone who opposes it, and there's kind of a heated battle between them. That probably won't happen as much in your commission. Again, most of your public hearings will be for legislative issues, but again, the fundamentals still apply. And the fundamental rules for public hearings is this idea of fundamental fairness. And there's lots of cases you could kind of get into the weeds a little bit on it, but I think there's really 2 really main issues. One is, well, first you need to notice a public hearing, which Nick touched on before, as with all your meetings. But you need to make sure that anyone who might attend the public hearing knows about it, is able to access it, and can speak when it's their time. So assuming you do the notice sufficiently, another is you just want to make sure everyone can speak. Other commissions that have, 100 people turning out for one public hearing, sometimes they get a little long. We get questions of can we, maybe limit what people say or try to move things along. Again, I don't think this is a major issue for your commission, but in certain circumstances, there could be grounds for instituting content neutral limits, universal timelines of 3 minutes here and there. But again, before you did any of that, you should reach out to the law department if you think that's going to be necessary, and we can walk you through that. But for the most part, when someone speaks, you want to let them speak. Hopefully, they're not too long-winded. If it becomes a problem, there are certain maneuvers that a chairperson can maybe do to curtail kind of just something that's going unreasonably long. But for the most part, you really don't want to interrupt their speech, and you want to make sure they get the chance to say what they want to say. Other part. Yep. Go ahead.
Based on that one last statement you made, could a person from the public comment on something that's off agenda, off of the, you know what I mean?
No,
No,
no, they have to speak to an item that's on the agenda, and
I see.
and
Okay.
also you could have rules, time limits on members of the public, on how long a member of the public could speak. You see that, for example, the Common Council has a 3-minute time limit.
What they speak about has to be on the agenda.
Absolutely.
Yes.
They cannot speak about something that's not on the agenda, because to do so is not fair to, as you think about it from a logical standpoint, it's not fair to the rest of the public, because the agenda comes out at least 24 hours in advance. The public has a night, gets to know what is going to be discussed by the commission. And if a matter that's not on the agenda is brought up by a member of the public and is discussed at a meeting with the commission, that's not fair to the public. And that's why anyone who speaks to a matter has to be a matter on the agenda.
Well, if it's,
By the way, I have seen over the years, it happens more with, the legislative body, means the Common Council, but I've seen it at other boards and commissions, not as much, but I've seen it where you've got to redirect a member of the public to say, excuse me, you're discussing a matter that's not on the agenda. I have to stop. I have to interrupt you and stop you right now. You cannot discuss a matter that's not on the agenda. Please move on to a different, please move on, et cetera. But you have to really strictly adhere to that rule.
but if it's a matter of concern to the Harbor Commission, and we would need to know something about what that person is talking about, then could we hold that off to the next meeting or bring that on the agenda?
Right.
Is that?
Yeah, hold it off there. I mean, they should reach out, very rarely that will come out with something that you don't know, but if they want something on the agenda, they can reach out to the commission, to the chairperson or staff person and say, I would like this on the agenda, and it's up to the commission to decide whether you should put on the agenda. But, so not only, one thing about the public hearing is that not everything is also, not only does it need to be an agenda item, but not all agenda items are eligible for public hearing. And again, sometimes that's helps with that. The chairperson, as Mario said, could politely correct someone. But again, there's two types of really items that come before you. Some items are just for the commission's deliberations, and then there are certain items that are required to have public hearings. If you're not required by statute or ordinance to have a public hearing on it, then the commission does not need to take public input from the public. In certain circumstances, discretionary, you could allow it, but you should put that on the agenda so everyone knows. So if someone were to speak about something not on an agenda, again, that's not appropriate. And if someone speaks about something that's on the agenda but isn't subject to a public hearing, again, that's not appropriate.
Yes, years ago, we used to have the Harbor Commission used to have State of the Harbor meetings. And because of COVID, the past maybe 4 or 5 years, we have not had our State of the Harbor meetings and we used to have the general public speak up and just give us general opinion, their opinion, how the harbor is going, if there's any issues that they want to bring up. And it was at that point that it certainly informed the commission of the general public's concern about how we're doing or how the harbor's being managed. So it was a time to certainly reflect on what we've done in the past and what the public has accepted.
And by the way, if you have a meeting that is, title for that has been noticed for that purpose, then it would be appropriate for the public to comment, because that is the topic, is, you know. what
Well, the
people-
the
what
topic
people's
was not,
thoughts-
it was just it was just freedom of not freedom. It's a state of the harbor meeting in which the general public could talk and speak whatever they felt. There was none on the agenda. It
But,
was,
but my point
Well,
is that the agenda would, if the agenda is that it's a meeting about the state of the harbor, then it gives the public the opportunity to speak
I see.
about it.
okay.
So again, that would be a meeting that would be appropriate for you to hear a comment from the public about the harbor, because it's been it's been properly noticed, so that any other member of the public who may be interested would know that it's possible that others will come out and speak about their opinions about the harbor, because it is the topic for the meeting.
Oh, God, great. Thank you. That was good. Thank you.
That makes sense.
And then the last thing about public hearings is for the items you do have a public hearing on, when the public hearing is over, please don't accept any, you know, and again, most of yours is legislative, so sometimes there's less evidence. Again, when there's an application, someone, there's a little, someone who's opposing a specific application, you get a little more concerned with evidence. But either way, again, the fundamental rules still apply. When you close a public hearing, you cannot accept any more public testimony, because again, the point of it is that everyone should kind of, you know, be able to get a chance to speak on the issues before you. So when you say that the public hearing is closed, you should no longer accept testimony, whether it's someone speaking at the meeting or written testimony, whether it's through email that goes to your staff person. When the public hearing is closed, nothing else should make its way to the commission. Because you don't want anything that you relied on that wasn't available to be heard by everybody at the public hearing. Again, that doesn't, probably less likely to apply to you, but it's something to be aware of. And I think that takes us to other issues, but best practices, more focusing on commissioner conduct, conflicts, recusals. Mario, do you want that?
Sure. So few things that I have go over with you. Conflicts of interest and recusals. So with regard to a conflict of interest, well, there's two things. One is a conflict of interest and one is an appearance of a conflict of interest. So each member must determine whether he or she has a conflict or the appearance of a conflict that would disqualify the commissioner from participating in consideration of an application. And a conflict exists when, for whatever reason, the member is compelled to consider the application differently than he or she would for a different application or for a different applicant. And generally reasons for conflict are personal and financial. You know, clear conflicts are family members, you know, mothers, brothers, spouses, in-laws, even if you don't like them. With regard to financial, you know, business partners, clients, anybody you have an ongoing financial relationship with, or ongoing business relationship with. Now, what's important is to understand that a lot of times when folks do recuse themselves for a conflict, it's not for an actual conflict, it's for the appearance of a conflict. So even though I wouldn't feel, you know, if there's an application involving, you know, my second cousin, I barely know the person, you know, as an apparent, I wouldn't treat them any differently than someone else, but because of the appearance of conflict, I'm going to recuse myself. And so quite often it's not that you actually are conflicted in the sense that you wouldn't treat that person or that organization any differently than you would another applicant. But if somebody could, if there would be the appearance that you would have a conflict, then for that reason you should recuse yourself, because it's important for all boards and commissions, to the extent possible, to maintain the public confidence. And you know, I've been doing this long enough, and a lot of you have been involved in public service long enough to know that no matter what we do, there may be, you know, members of the public who question people, even where it's not justified. But we have to do the best we can to maintain the public's confidence. So even if you don't think you have, even if you don't feel like you are conflicted, but you could see how somebody would say, hey, that appears to be a conflict. Try to err on the side of being cautious and recusing yourself.
We got a question, Mario.
Sure.
Yeah, a lot of people on this commission, due to the nature of the Marine, a lot of people are members of clubs. A lot of times clubs have business that come up before the commission. I think most of us have tried to be cognizant of, recusing ourselves if the Norwalk Boat Club, whatever, I'm trying to make one up, but has an application or business before the commission, that anybody who's a member of the club or an associate or has an association like that tries to recuse himself. I just wanted to clarify if that's doing the right thing, if that's
That's absolutely doing the right thing. I think that, and by the way, I tell folks, you're allowed to know people in town, and
Right.
you're allowed to have, relationships with people, and you're allowed to, know folks who come before you. The question is, at what point does it become a conflict? And, for example, in the town I live in, I don't spend a lot of time here because I'm working a lot. But because my kids are involved in sports, there's a lot of people I know in town. I may have coached their kid, and at some point, or my kid may have played on one of their teams, and I know them. Say hello to each other. If I was on a board or commission, and some, then a parent who I know from sports with the kids, comes before my board or commission, I probably wouldn't feel compelled to recuse myself because I wouldn't treat them any differently than anyone else. However, if it's, the parent of, a kid who is on my son's, on two of my, I'll give you one example, on my son's, regional competition team, and we're constantly with them, and, we go to tournaments out of state, and we have dinner together, and we have a relationship. Then I would recuse myself if one of them came before my board or commission, because probably would feel, you would at least have to think about, how would I treat them any differently, but just the appearance of it, I'm with them so much that it would be wrong for me not to probably recuse myself. So I mean, with it, obviously, if someone's a member of a club that comes before you, that's probably an easy one to recuse yourself on. If somebody comes before you that you don't necessarily have to recuse yourself just because you know them. But I think you have to use some common sense and say, would I treat them any different? Would I feel compelled to treat them any differently than someone else? If so, then absolutely you should recuse yourself. Or would there again be an appearance that I should have recused myself with that person? It's like defensive driving. You want to protect your reputation, and you should err on the side of recusing yourself if you think that there's a question about whether you have a conflict or whether someone else would question it within reason. Alan, do you have a question? Or no? I didn't know if I thought I may have seen a hand up. It's not up. By the way, it's not up to anyone but the individual member to decide whether he or she has a conflict. So somebody else can't make that decision for you. I can't make that decision for you. If you're a member of the board, of this commission, the chairman can't make that decision for you. It's your decision. Having said that, we're always available to discuss a potential conflict or appearance of conflict. And, quite often, a member of the Common Council or a board or commission member will reach out to either myself or Matt in the law department and say, hey, I want to bounce this off of you. I want to know whether you think I may have a conflict here, or an appearance of conflict. And I got to tell you, I don't always say, yes, you should recuse yourself. Sometimes I do. And sometimes I say, I really don't see it. I think it's great that you're being cautious. I think it's smart that you reached out to me to discuss it. I don't see the conflict, and I don't even see an appearance of conflict here. There's other times where I said, yeah, there's a conflict. You should definitely recuse yourself, or there's definitely an appearance of conflict here, and you should recuse yourself. So we're always available if you ever want to reach out to us. and ask for our confidential advice. Lori?
Mario, I know it's different now that things are on Zoom, excuse me, versus meeting in person, but can you describe recusing yourself? I know it used to be that you would leave the room at the beginning of the conversation, but what do you do now with Zoom?
Great, that's a great question. So a couple things. First of all, if we're in person, tell folks, if everyone's sitting at the table and you recuse yourself, you leave the table. Not just during deliberations, you should leave the table during the entire hearing on the matter. So I think similarly for a Zoom, you would take yourself off as a panelist during that time. You would not, I'm recusing myself from this application. You take yourself off as a panelist. You could watch it like a member of the public, but you should be off as a panelist. So you should be off as a panelist for that matter during the hearing and during any deliberation session regarding it. And then you come back on as a panelist for the rest of the meeting. That's my advice as to how to handle it with video.
So with the staff person, sorry, I just want to make sure we all
Sure.
understand this. So if I say I'm going to recuse myself for this application, then would our staff person, Amelia, change my permission? Or
I would, if that was me, I would just X out, get out of the meeting, go
okay.
on to what I would do is just go onto the public link. So there's a link for the
Oh,
public.
okay. I'm with you.
So all
Yeah.
I would do is, if it was me, I would just X out.
Got
And
it.
I'm not the most tech savvy guy, but I would just X out of it. And then I would go onto the public agenda and I would just jump on as a member of the public. What I would do is, I would tell the staff person, I would tell Amelia in advance, by the way, I'm going to recuse myself here. I'm going to get off. When I get off, please don't promote me back. So when you see me back, don't promote me back during the application because you're defeating the purpose of me doing that. But I'm going to go back on and listen because I want to know when to come back on. And also you have every right to listen to the application. I would, but you certainly don't want to be seen.
Right.
And maybe, we're being a little overly technical, but you don't want to be seen as being on the board while it's processed, while the application is going forward. So you want to make sure you're not on as a panelist.
And I've even seen folks who have recused themselves during remote meetings, even go so far after joining the public link just to watch still, to turn their camera off to avoid any conscious or subconscious facial.
Oh, by the way, that's a great point. I just assume if you're a member of the public, you're not on camera. But just to be clear, if in fact with our public link, and I don't know, because we have so many towns to represent, I don't know what we do. If you're a member of the public, usually my experience is you're not on camera. But if you are on camera as a member of the public and you're listening, absolutely it's not even a question. Make sure your camera's shut off. Yeah. You shouldn't be. You should try to make sure you're not on. I'm glad, Nick, that you brought it up because I didn't even think of that. I just usually you're not on camera when you're a member of the public.
Okay, thank you.
Ms. Pinto.
Yes, Mara, thank you. Again, I'm not, that tech savvy, but doesn't the host have control over whether they can put that person in a side conference room or not? I don't know, Amelia, isn't that, because I do that with some of the Zoom conferences that I have with our students.
You don't want to be in another room because you're going to be in a room by yourself.
Well, no. It's you're there in the meeting, but you're not privy to what goes on in that meeting.
Well, I was going to say, yeah, but what I'm saying is you could listen. Like, I don't think there's anything wrong with listening. If you recuse yourself, you could listen. In a live meeting, the advice is, leave the room because you don't want someone on the commission to see you and you could, someone could accuse you of influencing it because you happen to be in the room. For video, we don't have to worry about that anymore. You could listen to it as a member of the public and no one sees you and there's no potential accusation that you would that you would somehow influence the group.
I see. Okay. Thank you.
So, again, I think the best thing to know, the best thing to leave you with on conflicts is, or appearance of conflict is, if you ever have a question, Matt or myself or Nick we're always available. You could get our contact information from Amelia. And, you know, I'm available, you know, and so is Matt, you know, at night, on the weekends, if something ever comes up, you know, one of us is more than happy to talk to you at any time. And I ask that, you know, if you ever have the question, please don't hesitate to reach out to us. I mean, with regard to bias and predetermination, I think it's more of an issue that comes up for those boards and commissions that are subject to litigation, like a planning and zoning commission, where somebody will try to make that accusation of bias or predetermination and try to make it in a court appeal. So, I mean, the whole concept of bias predetermination is that you prejudge the application in a way that's not fair, or you're somehow biased. You're either predisposed to decide it one way or another, or you're biased to the application or the applicant. And so when does this come up? Well, it comes up when, quite frankly, board and commission members do things that are not too bright. So if you've got an application that's coming before you, it's not wise to go on social media and start talking about it and commenting. Because then when that application comes before you, it's pretty easy to see that you had an opinion. So you were either biased or predisposed.
Nobody
Even if we're,
knows
you know,
opinions on social media. That's a.
Yeah, I mean, let me put it this way. I shouldn't have to tell you, but it's a big no-no.
I
to get
laugh
on
because social media is like nothing but opinions about Norwalk.
Yeah,
Politics is ugly here.
Yeah, or to get on the comment section of the hour in Nancy and Norwalk. It's not as popular anymore, but to comment
Yeah.
about something that is going to potentially come before you.
Yeah.
So just don't do that. And you know, as lawyers, we're pretty careful. We're not perfect. Some, you know, you always see in like a news report of somebody who gets in trouble with something, and you know, and they show the text messages or emails, and you say, boy, that was really stupid. Why'd you put that in writing? So same thing. If it's something regarding an application, you know, you shouldn't be, if there's an application that's potentially going to come before you, you shouldn't talk about it with anybody, with others. You shouldn't express opinions about it before it comes to you. And you sure as heck shouldn't, like, you know, communicate in writing about it in advance. And here's the other thing, spouses. Now, I don't know about the rest. I am not suggesting any of you could control a spouse or partner. I certainly, yeah, I've been married for a while, maybe not as long as some of you. I sure as hell can't. And I can't control my mother-in-law either, or even my own parents. They say things and I, like, you know, you scratch your head and say, oh my God, I can't believe you just said that. But if somebody's your spouse, or like, you know, your kid, your parent, your child, or, you know, for those of you who are a little older, or your parent, for those of you who are a little younger, has the same name as you, you know, last name, comments that they make about something that's going to come before you, that could be an argument that you've been prejudiced or biased because, you know, your partner, your spouse has publicly commented about an application that's going to come before you. So, you know, be really, you know, again, I don't expect any of you to control your spouses, your wives, your parents, your in-laws. Just be cognizant of it. Again, not as much of an issue with your board. That's more of an issue with like the Planning and Zoning Commission, you know, high profile application coming before it. And there's been a lot of public discussion about it, you know, in planning phases for a while. And so that's the commission that I'm more concerned about bias predetermination. If you look at the case law on it, planning and zoning commissions are the ones that probably get targeted the most for claims of bias or predetermination. So not as much of an issue with a board or commission like yours. But I like to hit on these topics because I find them to be interesting. They're a hell of a lot more interesting than some of the things that Nick and Matt talked to you about this evening. And we could talk about it for a while longer, but I don't think we need to because you know, I can just tell by your facial expressions. I think you all get it, and I don't think it comes up a lot with your commission. But I'm certainly again available as well if any of you ever have a question about whether you've done something or somebody close to you have done something that you think could lead to somebody accusing you of bias or predetermination. You wanted to speak to us about that before you hear an application. We're always available to have those conversations in confidence with you as well. So moving on, I think for you, Matt, were you
Pretty much
finishing
near
us
the
off?
end, Mark. Yeah, we covered ex parte communication earlier up, so I think we've pretty much reached the end of the outline at least.
Before we're, I guess, as we're kind of, well, by the way, we targeted with these training sessions to try to get them done in about an hour to an hour and a half. So, you know, we're kind of close to the end here. Is there any questions that any of you have for us, or any topics that you'd like us to address before we're done?
I would like to just thank you all for coming and doing this for us. It's something we've advocated for a while, and I think we're looking forward to doing this perhaps with some other city departments as well that we interface with regularly, so that we get to know each other a little bit, but also kind of learn the rules of the road. So, you know, Mario, Matt, and Nick, I really appreciate you giving of your time to help us understand a little bit more about what we're doing. We really do appreciate your insight and making yourselves available to us as well. It's really very important for us. So thank you very much for coming.
Thank you for inviting us this evening, and quite frankly, it forced Matt and I particularly to look at prior legal opinions we did and kind of refresh our understanding of what the rules are and laws applicable to the Harbor Commission. So, you know, we otherwise wouldn't have done it. So this was helpful to us as well. And, you know, again, we purposely don't give the handout in advance. Matt has taken a more strictly applied that the last few training sessions, apparently, by not handing it out until afterwards. But we do it on purpose because we want to go through it with you fresh during a discussion. But to the extent that, you know, any of you have questions after you've reviewed the materials, I just ask, you know, feel free to reach out to us. I just always ask that it go any communications request for anything with the law department, with the exception of somebody wanting to ask about a potential conflict. I ask that all those other inquiries, and this is across the board, our policy with all boards and commissions, that it always goes through the chair. So that's always our request with all boards and commissions, that you go through the chair, unless it's, I think I may have a conflict. If that's the case, then just reach out directly to us. John?
Yeah, Mark, just a quick question, because we're confronted with this issue right now. And I'm questioning about the term binding, how a lawyer looks at the term binding. The harbor management plans contain the state's recommendation that when we review an application, that our recommendation about that application is binding by any state official, unless they show just cause to why they chose a different action. And my question is that this is the issue that the DEP now has with regard to that they're considering that this means the commissions have a veto power over what the DEP says, and that is not what the state statutes say, and that's what the DEP says in all of the Harbor Commission management plans. But the issue of binding tends to be a hang-up for them. And I was just wondering if there's any other phrase that we could use other than binding to sort of say that, no, this is not binding and that we have absolute control over that decision, but that they need to show just cause as to why they chose a different action. And that's all that we're requesting. And that's what they have recommended in all of the harbor management plans that they've put up together. But now there seems to be a problem with that now.
To the extent that it is becoming a problem, you said is DEP, right? I mean, I would suggest that, you know, we have a discussion with DEP, and obviously we can't have it with the full board, with the full commission. So maybe the chairman and, you know, a staff person and someone from the law department, we have a discussion with DEP and try to discuss the issue with them.
Well, that's what the state, that Cohen versus that Greenwich case had stated. That the binding tended to be a problem with the DEP. And so again, all right, maybe at a later time, we could probably talk about that because it's a major concern because it's going to negate anything that the Harbor Management Commissions can do in the future with regard to any application to the state.
Yes, it's kind of that Cohen versus Greenwich case is complicated. I know that it touches on a lot of that, John. It uses the word binding, and
Yes.
it gets a little complicated. But generally, again, and this is an oversimplification. But you know, in that case, there was a little disagreement between whether the Harbor Commission had authority over something or the state DEEP, or whether DEEP had authority over the same issue. And in the court analyzed and said, well, because there is a language that says that the harbor commissions, some of their decisions could be binding on state officials, but the court kind of analyzed it to say, well, if it's in your harbor management plan, then DEEP has already approved your harbor management plan. So DEEP has pretty much implicitly given you, conceded some of its jurisdiction to you on that issue. So if it's in the harbor management plan, and again, it needs to be analyzed case by case. I can't give you a definite, so that's why you should reach out. But if it's in the harbor management plan, that tends to give, and generally speaking, the Harbor Management Commission a little greater authority on that issue. But if it's not in the harbor management plan, then the default power is with DEEP. So again, you really have to take issue.
That's where the catch-22 situation comes in that we cannot have every application explicitly outlined in a plan. That's the problem I'm having.
And
so
that's what we can work with. Maybe we could do broader language. Again, a lot of this hasn't been tested, and you know, we can look at continued cases and we can see what other towns are doing. But we're not the only. You're not going to be the only harbor management commission
no.
dealing with this issue.
we're not. As a matter of fact, we're not.
And by the way, I think from the state's perspective, it'll be, you know, that unless it's within your plan and they've approved the plan, they don't want to give you authority ultimately over it. And I could see the rationale for that.
You see, we're not asking for authority over it. We're only asking for why did you choose a different action? Because what we've had in the past is that we've made a decision or made a recommendation, and the DEP has chose a different action. And now what we need to do, because we're now holding the bag, because we have to contend with our constituents, is well, why did you say it was okay here, but it's not okay over here? So we need some means of justification of why they chose a different action, because we're left with that decision, and we have to explain to the general public or another applicant as to why that person can do that, but this person can't do that.
John, I think I get your question, and I mean, we'll just, and Matt will have to drill down on that case a little more. I mean, if I'm hearing the question right, it's what's in the statute in that section 113N that has the word binding. Right. And it says the plan shall be binding on the state, but then it goes on to say unless such official
exactly
shows cause. So what does that show cause mean? And what, you know, what's the threshold there? Sounds like is your question.
Explain to us why you chose a different action, different tack. Because now, as I said, we have to go back and explain to our constituents, or let's say another applicant, of why you allowed that to happen, but you can't allow us to do this. And so this is my concern of what we can do, and it sort of binds us right now to do nothing to an application. We can't even review an application unless it's clearly specified in the plan. And that makes no sense because, as I said, who foreseen the Walk Bridge project coming in? So we couldn't have had any aspect of the Walk Bridge project. We had to discuss the Walk Bridge project, but we used recommendations and policies based on the plan to make a recommendation.
And it could depend. Maybe you don't need the word Walk Bridge, but that's why it helps us to talk it through, and we could talk offline and really kind of explore that issue with you. But maybe you don't need the word Walk Bridge, but maybe there's another word in the plan that covers it, and how broad you could be is a legal question in and of itself, that we may or may not give you a decisive answer to. But if DEEP does kind of override, you know, your opinion based on that power that they have, where they say there's a very good reason for it, you know, to some degree, if you're worried about someone saying, well, how come they did that? You know, it's a question for DEEP, and there may be ways to compel DEEP or ask them nicely to explain their reasons for us, so we can inform the person at issue, or the person at issue can reach out to DEEP as well and say, well, how come you did that in that case? Because, but so there's a lot of, that's a great question and point, and it looks like there's a lot to be explored there.
No, thank you very much for that, guys. Thank you.
All right, well, again, thank you for inviting us this evening. I'm more than happy to do it again in the future. and we're always available to you, be of assistance. Thank you again, everybody, for taking the time.
Thank you
Thank
very,
you.
very much. Thank you.
Thank you very
Thank you.
much.
Thank you.
Have a great night, everyone.
Night, everyone.
You too. Take care.